Hi, everybody. Thank you for joining us tonight. I am Josh Bolin with Carpenter, Hazelwood, Delgado, and Bolin. So little things we're going to do today is you're going to be muted. Vito will continue to mute people that join. If you do have any questions as we are going through the presentation, the easiest way is to go to the chat function, and you can chat me your questions as we go through things. And that way everyone can see them, or you can chat me directly, and I will do my best to answer the questions as we go along. This way I'll keep down background noise and people from muting or unmuting. So greatly appreciate it. Thank you everyone for coming out. Vision, thank you for having me out tonight. Today we're going to talk about the top 10 legal issues for community associations in 2021. The scary part is that we're almost in March. I mean, we blinked. It seems like it was Christmas 2020 not that long ago, and already coming up on Sunday, we're going to already be in March. So time is flying. So some of these issues we may already be dealing with, and some of them I anticipate are going to come up. Let me get my screen here. So we are going to do this top 10 style, David Letterman style, although I admit that I already messed this up because David Letterman would go 10 to 1. I'm going 1 to 10, but mine have no order of importance. They are all 10 equally as important. Again, my name is Josh Bolin. For those of you that don't know me, I've been specifically practicing in the area of community association law for the past 16 years. I am the past president of the Community Association Institute. I serve on various legislative action committees. I have lobbied down at the legislature on behalf of community associations for 6 years, and I've served on a number of boards. So I completely understand everything that you've gone through as board members and members of your community, and greatly appreciate you taking out the time to address with me. I already got my first question. Were there any new legislation issues this year? Yes, and that is going to be something that we are going to get to. So top issue that we're going to talk about in the top 10, marijuana, Prop 207. So my firm actually has an office in Colorado. We have a couple attorneys that practice in Colorado. I'm licensed in Colorado. And the good news is we have experience already dealing with marijuana issues in community associations. What the people in Colorado tell us is if we have not had marijuana issues yet, don't worry, you will. So we're talking about not only Prop 207, what it means, what are the new laws for marijuana, but how they may affect your community association and steps that you can take to help address those issues when they do occur. Next thing you know, we're going to talk about the housing market. So we're all been waiting for the housing market to come back to normal. It's been increasing even in 2020 as the pandemic's been happening. The housing market has been seeing prices and a number of sales continue to skyrocket. And because we deal with communities deal with houses, this is a very important issue for us to understand for a variety of legal purposes. So we will also talk about those today in the housing market and the legal issues that it'll cause. We're also going to talk about construction. Not only construction within your community, but how construction around the valley is affecting you. No matter where in the valley or where in the state of Arizona you exist, there's building going on. I currently live in Tempe, but I just moved to Tempe a couple months ago from Gilbert. When I was living in Gilbert, there was not an area or a dirt lot where they were not trying to build homes on. And with construction, a lot of construction comes growth, but with a lot of construction comes a lot of construction issues. And it also skyrockets the market for the cost of construction. So if you're going through construction projects, or if you're looking to have construction in your community, we're going to talk about steps that you can do to consider. Now, these next topics, the housing market and the construction, these next topics are going to help address those issues. One of the things that we need to talk about is reserve studies. With construction going on, we want to make sure that we are fiscally responsible with our reserves and what we can do to ensure that we are saving up for our community. because like it or not, one of your jobs as board members is to care about what your community is going to look like in the future. A lot of board members think, hey, I'm not going to live here in 5 years. I don't plan to live here in 10 years. Why do I care? Well, because the law tells you to care. And so we're going to talk about the reserve study, things that you can do to help with a variety of reserve issues. Then we're going to talk about architectural requests. We are seeing an influx in architectural requests and architectural issues at the firm, and for a variety of reasons. Top one, houses are selling. People want to put money back in their house to sell their house. Also, people, because the housing market is high, cost of buying a home is high, people are now investing back into the property because they've decided they're going to stay there longer. So we've been seeing a ramp up in architectural requests and architectural request issues. So we're going to talk about those also and affect your community and how your community can protect yourself to make sure that you don't run into some of the issues that we are seeing. Then we're going to talk about contracts. Why it's important for the association to enter into contracts, what an association needs to look for in their contracts, and why are contracts so important for community associations. Next, we're going to talk about unemployment. It is a weird thing that we are seeing, and most of your communities are probably seeing this, is that although unemployment and the pandemic have been happening, most associations are doing fairly well from a bad debt or delinquency issue. Most delinquencies in most communities are down, although employment is up. And somehow that doesn't make sense. Some of it has to do with the marketing, some of it has to do with equity in homes, some of it has to do with people with disposable income. So we're going to talk about unemployment and why we need to monitor unemployment and the current unemployment, what it can do to affect your community association. Then we're going to talk about AZDRE complaints. If you don't know what an AZDRE complaint, the Arizona Department of Real Estate has limited jurisdiction to hear community association issues. This has been something that's been in place for the past 8 years, but we are seeing a dramatic increase in the number of complaints that are being levied at the Arizona Department of Real Estate. And we're going to talk a little bit of why that is, steps that you can do to prepare for it, and really that's so you can be aware of what they are when they do occur. Then we're going to talk about bad legislation looming. There is one bill there. The good news is there is only one really bad bill pending right now with the legislature. There are about 5 bills that could affect community associations. 4 of them are good, 1 of them's neutral, and 1 of them is really bad. So we're going to really just talk about the bad one. And the reason why we're going to talk about it is it may never become law, but it's something that if it does, you need to be aware of. And it's also something that you and your boards may want to get together to contact your representative to talk about this bill and how it could affect your community. So there is some bad legislation looming. And then finally, we're going to talk about, can we please just get back to normal? What is normal? What is it going to look like? When can that start to occur? What things do we need to consider getting through the pandemic? When are we going to hit certain benchmarks? What is the government telling us we can do? And even ask ourselves the question is, what do we have to get back to normal? Or if there are things that we like, virtual meetings, different things like that, can we just continue to do it that way? We're going to talk about that because although we want to get back to normal, maybe the past normal is not what works for your community going forward. And so we'll talk a little bit about those issues. So those are our top 10. Hopefully we will go about an hour and 15 minutes. I always have a saying that nothing good happens after an hour and a half. So you can use that for your board meetings because concentration breaks, people are hungry currently right now, time of day. So let's jump right in and see if we can get done in about an hour and 15 minutes. So let's talk about Prop 207. So Prop 207 amended Title 36, the Arizona Medical Marijuana Act. So if you don't know, the Medical Marijuana Act is still in place. People can still get prescriptions and get cards for medical marijuana, anyone over the age of 18. So there's already a gap in the idea of kids over the age, or adults over the age of 18, can still possess marijuana if they have a medical marijuana card. However, with the law passing Prop 207, it allows adults 21 years or older to use, possess, or transfer up to 1 ounce of marijuana and cultivate marijuana for personal use, not more than 6 marijuana plants at their primary residence. So use, possession, and transfer, and also be able to grow marijuana at their primary residence, so at their residence. So immediately, things that jump out to us, people can now use marijuana at their home, in their communities, potentially, and also will be able to grow marijuana at their residence. So these are automatically already things that are going to affect our community associations. However, the good news, none of this act or nothing that changed under Prop 207 impedes the contractual rights of associations. So if we have the ability to adopt rules and regulations or prohibitions of things that may be allowed under this prop, they don't affect the association's rights. So the good news is there's steps that we can take to help get in front of these issues. Because as our neighbors to the north, Colorado, is telling us, your communities are going to have these issues at some point. So what steps should we be taking, and maybe adopting rules and regulations, guidelines, and those different kinds of things to make sure that we are getting in front of these issues. So let's talk about the cultivation issues. You can cultivate up to 6 plants, but it's really not more than 12 plants, as long as there are 2 individuals who are at least 21 residing in there. So if you have a home where there are 4 adults who are over the age of 21, they're limited to 12 plants. But the 6 plants really only could be anywhere from 6 to 12. So they're allowed to grow them at their primary residence. Okay, and that can include any condominium unit, a townhouse unit, or in a single family planned community. The good news here is it must take place within a closet, a room, a greenhouse, or any other enclosed area on the ground. So it can't just be, you can grow marijuana in your front yard. You can't go into your garden and just start growing marijuana or grow it on the balconies or different things like that. It actually has to be an enclosed area. And the reason for this is they don't want children to have the access to it. And they don't want anyone in the general public to be able to access it. And this is why one of the other requirements for it is that not only do you have to have it in one of these contained areas, but it also has to be equipped with a lock or some other security device. Basically, again, where general public or children cannot get to it. And the area also cannot be visible from public. So this is already good news. So one of the concerns was, hey, can people start growing it in their front yard? Or can they start growing it on their balcony? Can they grow it if there's view fencing, different things like that? The answer is no. But here's the trick with all of this. With these issues, if somebody is violating any of these provisions, is that really an association issue? Perhaps not. It could also be a police issue. If somebody was growing marijuana openly somewhere in the general public, that would be an issue for the police to handle. The association doesn't have the right to enforce these provisions or this law. We're going to have to rely on law enforcement. However, there are steps that the association can do to help protect itself from cultivation issues. One, we can look at our guidelines and figure out if we have the ability to prohibit structures. So again, this Prop 207 does not impede on the association's rights under its documents. So if we already prohibit sheds, or we prohibit greenhouses, or we prohibit any structure that may be visible from neighboring property, we already have the ability to address these issues. So we look to our use restrictions to see if we can prohibit those types of structures. If not, then we look to our ability to adopt architectural design guidelines. And does somebody need to obtain approval to build something like this in their backyard? Most of these greenhouses and most of these sheds have to be pretty substantial. If you've ever done your research on marijuana, it can grow, even 6 plants can grow to be fairly large. So these have to be somewhat large structures for them to exist. So we look to those to say, hey, can we adopt guidelines that require people to get approval for these structures? If we can't, maybe we need to adopt specific guidelines that address these issues. And then we fall back into the reasonableness and the language set forth and our ability to adopt architectural guidelines to figure out if we can prohibit these types of structures, or if an owner needs to obtain approval from the architectural committee or design review committee prior to building any of these types of structures. The other issue here is one of the bigger things, I think, is not really the planned community part of it, but the condominium aspect of it. This would allow people who reside in a condominium to grow marijuana or cultivate marijuana on their property. So if you're not familiar with marijuana, one of the ways a lot of people grow is through hydroponics, which is essentially growing vegetation under lights with watering system indoors. And Prop 207 and the law recognize that, because if you remember going back to the language, it talked about the ability to grow it in a room or in a closet. Well, you think of a condominium, you think of, okay, they have two of those things. So they would have the ability to grow in this. So we look back to our condominium rules to say, hey, do we have the ability to prevent something like that? And there can be different things about unit growth, growing things, prohibiting the growth of any type of vegetation or anything in certain areas of the property. Again, remembering that it has to be in a locked, secured area. But there's also this idea that the water use. Some of your condominium documents prohibit the owners from doing anything inside the condominium that may affect insurance. Scott Carpenter, one of my partners, a long time ago dealt with this issue before it was popular, where somebody was growing hydroponics throughout a condominium unit. And the reason why the condominium became aware of it, the condominium association became aware of it, was simply because it got flooded. They forgot to turn the water off and it flooded the entire unit. And they went in and said, hey, now there's all this damage. Do we have the ability to restrict water use or different types of insurance concerns whenever these things may pop up? So we need to look to our governing documents as the ability to prohibit, even inside the unit, people doing things to cultivate marijuana inside a condominium unit. But all those are going to be document specific. We need to have this language in our documents in order to address these issues. If we don't, we either need to adopt the rule if our rulemaking authority, or we need to amend our CC&Rs. Then we have the issues of use. Okay, so we talked about cultivation and what we can do to help get in front of those issues. But we're talking about use. One of the questions I got, can people sell what they grow on their property? No, that's a very good question. It is for personal use. So you cultivate plants for your own personal use. This does not allow anyone to sell marijuana. That selling or regulation of marijuana, of course, is regulated to dispensaries. So that personal growth is for your own consumption. It does not allow you to sell that or even give it out to other people under that. So very good question, Ursula, thank you. So we do have use issues. So what are people's rights to use it? Well, we have the ability under the inherent ability, not only under our documents, but under Arizona law and the restatement, to adopt rules regarding the common property. And the law does not allow people to use marijuana in the public part of it. And this would even include, even though our common areas are private, we do have the ability to adopt common area rules to prohibit people from smoking or even ingesting marijuana on the common property. Think of it a lot like cigarette smoke and people smoking at the pool or smoking on the balconies or smoking in the common areas. We do have the ability to regulate those by adopting rules. So one of the ways to get in front of this is to make sure that we adopt good rules that would strictly prohibit the use of this. Other issues is going to be nuisance claims. So one of the biggest issues that they're having in Colorado that community associations always deal with is neighbor-to-neighbor complaints. That would have to do with if somebody's smoking on a balcony or somebody's even smoking inside their unit, but it is going into another unit, or somebody is smoking in their backyard and it is affecting somebody else in their other backyard. These are what we call nuisance claims. It's basically something that's happening that is affecting the peaceful enjoyment of the use of someone else's property. So, but for us to have a good nuisance claim, we need to make sure that we have good nuisance language in our governing documents. So we always assume when we talk about association documents, because 90% of documents have some kind of nuisance provision that allows the association to enforce it, but some of your documents don't. And if some of your documents don't have that specific language, then we need to look for something else to try to combat these nuisances. If not, then maybe it's a private nuisance and it now becomes a neighbor to neighbor dispute. So I'm going to grab a few questions here because it looks like I got good questions. The laws do not change about using marijuana on public property, right? That is correct. It is still prohibited from being used in the public. You're not allowed to use marijuana in the public. If we don't prohibit cigarette smoking in common areas, can marijuana smoking be prohibited, or do we have to allow it? No, I don't think there's any kind of protected class that would protect people from smoking marijuana versus smoking cigarettes. There's a lot of science out there that talks about secondhand smoke being deadly. There's also a lot of science out there that talks about the secondhand smoke of marijuana and how they could affect people's well-being. And there is also an issue that we're not going to get in really today, but if you wanted to go back and look at it on our website, talks about even fair housing issues. What happens when you have a competing fair housing right? If somebody who needs marijuana for a medical issue versus somebody who has a medical issue and can't be exposed to smoke. So those are two things that you have two battling fair housing issues. We're not going to get into today because we could go for hours, but something definitely to look. Do these rules belong in the rules or in the CC&Rs? They can be in the rules. Regarding of where they occur, you have to look at your rulemaking authority, and you also have to look at your documents. So if you have good rulemaking authority and good nuisance claims, definitely those can just be a rule or policy or procedure that the association can adopt. May want to get with whoever your general counsel is to make sure that you have the proper authority. So condominium rules. One of the things, again, is we probably have more rights under condominiums to adopt various other rules. We have condominiums already that are, especially high-rise condominiums or condominiums where they tend to live on top of each other, already going out of the way to adopt certain rules. One of the rules is if it can be observed or smoke can be smelt from the common area, patios, balconies, hallways, different things like that. We can adopt rules and regulation that would prohibit people from using it inside their unit. Basically falling not only on the condominium rules issue, but looking back on a nuisance complaint. So all of this, we need to look to see what the language says in our documents, what is the makeup of our community, what kind of rulemaking authority do we have to address these issues? Because yes, some of you may have porches and different things where that's going to be more of an issue. Some of you may have backyards that are going to be close together that may have these issues. And all of you are probably going to have a variety of different language and rulemaking authority and ever to do this. So one of the questions I got was Colorado was very liberal in where one could use marijuana on their property. One could use on their porch or in the open garage. Do you see this similar in Arizona? Yeah, right now it doesn't prohibit somebody from using it on their property whatsoever. They have to use it on their property. It doesn't designate where on the property they can use it. They're just allowed to use it on their primary property. So use of it could be an issue. So with associations, we need to see what we can do to kind of tailor those uses to kind of prohibit some of these issues that we are foreseeing. So what if you do get a nuisance complaint? What if you do get an issue of somebody saying, hey, my neighbor's smoking, this is bothering me. There is an issue of potentially first thing we need to figure out, and this is a question that's being asked, are there any different rules for medical versus recreational use? There are. So with medical use of marijuana, there's, of course, you're protected through fair housing. Any of you that have ever had to deal with a disability accommodation request, medical marijuana is treated as medicine and therefore may have protections under fair housing where recreational wouldn't. So there is a difference between medical and recreational and what we can do to prohibit those. But our job is to set rules. And then if someone has a medical reason for exempting that, they need to ask your permission and accommodation for that if they need it for medical purposes but the association does not have to narrowly tailor its rules to address those issues. So what if someone does come to you with a neighbor-to-neighbor dispute? What are the things that we look at for nuisance claims? Determine whether this issue is a slight inconvenience or a petty annoyance. Some of you may have what we call an eggshell plaintiff. You may be more sensitive to smoke than some others. It may not bother us all the same. So we need to ask ourselves that to figure out if it's a real issue. Seek information from the complainant regarding the extent of the harm caused. People who are complaining about, hey, this is a bigger nuisance to me because I have asthma, I'm disabled, whatever it may be, that could add to the level of a nuisance claim. We can also seek information regarding the frequency of the interference. I do have an experience of before all of this became legal that somebody was having smoke parties in a high-rise condominium, and they were apparently inviting friends over to do it all day. And when I got off the elevator, there was no doubt that it was a nuisance. And it was no doubt that it stank so bad because of the frequency of everything going on, and that nobody who was walking that hallway would not have been bothered by it. But that's something that we also can investigate. And we need to make the determination if it's substantial or unreasonable. If this is something that's really become more of a public nuisance rather than just a private nuisance, and whether or not the association needs to get involved in it. So although we do have neighbor-to-neighbor disputes with nuisance claims, there are a lot of factors that we need to look at in order to see if that is a violation of your governing documents. But that is kind of the protections that we have. So just kind of a refresher on rule number one. Cultivation issues, look to your architectural design guidelines, look to your use restrictions to see if there's a way to address any kind of cultivation issues. Use issues, the first thing we look to is adopting rules and regulations regarding use and the prohibition of use on our common property, whether you're a planned community or a condominium. Then we look to whether or not we have the ability in a condominium to restrict the use inside of a unit or on maybe limited common elements. Planned communities, then we look to our nuisance language to see if we have the ability to regulate the use of recreational marijuana on a lot if it's causing a nuisance. So those are all the things that we need to look for. Again, our recommendation here is to look to adopt these rules and put them in place before you need them. It's always difficult to adopt rules and regulations when there's already an issue. We do think that you're going to have these problems most likely in 2021. So it's a good thing for boards to get in front of. All right, so next topic, housing market. The great thing about Arizona is the housing market is booming. That is a good thing for all of our communities. I remember community associations. What's the one thing that we always hear is that we are there to protect the fair market value of everyone's home. Not only are we there to do that, but I would make the argument that we are also there to increase the value of everybody's home, because all of you as homeowners inside your community, I'd assume you've invested a lot of time and money in your property and you want to continue to see it grow. And in Arizona, if you look at my little graph that we have here, is continuing to grow in terms of in the top 10 housing prices. So what does this mean? Housing markets continue to go, lots of construction, more competition for the communities. Developers are out there building new products, adding new amenities, doing things that would attract people to their communities. Everything that we look for as a community association when there's more construction, we want to continue to protect the values of our communities. So this always does make more competition, which would increase the association members from coming to the boards to say, hey, we want more amenities. We want more stuff. We need to compete with some of the surrounding communities to make sure that we are keeping up and increasing our value. One of the things right now at the housing market increasing is a lot of people are waiting for the bottom to drop out. That is the part that we are doing. And in an association, it's tough sometimes when you are in limbo of wanting to go out and do new projects when you have a lot of money coming in, but also being careful of not expending too much, because we don't want what happened in the downfall in the 2008, 2011 kind of era then we're left holding basically all these amenities and all these deficiencies and everything are happening. So right now it's kind of this awkward feeling of is it really booming, or are we just waiting for the bust? The experts on this are all over the place. What I have read from the research that I have done is in 2021, there is no kind of evidence that this is slowing down anytime soon. They are predicting in Arizona, and these are Arizona numbers, that sales are going to go up 11.4% over 2020, and that values are going to still increase over 2020. So that's good news for at least of what we're predicting in 2021 in terms of house prices and sales. And why that's important for sales and value to go up. People have more equity in their property. They're more likely to continue to pay their assessments. We are getting new owners into our community, which if you have resale assessments and those different types of things, helps with funding, gets rid of delinquencies, has people when moving into their property that usually want to upgrade their property. So a wide variety of different things that we can see with these increases, but it's something that we always need to keep in our back pocket. So what does this mean for your HOA? Well, we need to kind of look at our planning. What are we going to do? Is this the time to increase our reserves with our deficiencies being down? Should we plan to do more? Should we plan to do less? Should we ride this out in 2021 and then handle 2022 whenever it may occur? Different things like that. We also need to look at, is this going to create, one of the questions I got, and this is a good question, is this going to increase the number of rentals? Right now, what we are seeing is the data is telling us that rentals are actually decreasing. And the reason why rentals are decreasing is because investors are now selling at the top of the market, and they're selling to people who want to be here. Most of the people who for the sales that we are seeing are not investors, because or it's hard to flip a property currently, and it's also because you're buying at a very high price, and most investors are looking to buy lower. So what the data is telling us is that actually rentals in communities are actually going down. So one of the questions I got about rentals, I think it's covered by the percentage of units, people buying homes. There is a part of, if you want to be FHA certified, that there is a restriction requirement. Sometimes it can be in your documents, but to be FHA certified, there has to be a 20% rental threshold for that part of it. But we are seeing actually rentals decreasing currently, which some may think is good, some may think is bad. What else does it mean for an HOA with all these sales? Is turnover. Turnover in new members. We love new members. We love new energy. We love them coming in the community. But with most new members, they don't read their CC&Rs. They don't have the experience of things that are going on. And with that, you can see a lot more violations and those different types of things. Some of your communities may also be turned over from developer controlled. If you happen to be one of those communities that's being turned over to developer controlled, to homeowner controlled, you may have to deal with a number of those issues and work through a number of transition issues. And we're seeing a lot of this transition happening because with the number of sales going up, developers are being required to turn over control of their community associations to homeowner control. This also comes from education. We need to educate these new owners. Sometimes we train all of our owners for some of our more difficult restrictions, street parking, those different types of things. And now we're left to try to educate the new people who are coming into our community about the association. Question I got, this is right on track. We always seem to have homeowners to say they never received the CC&R from the realtor. I can tell you that's probably not the case because they probably haven't read it, because under both the Condominium Act and the Planned Community Statutes, there's an obligation to disclose the CC&Rs at the close of escrow. There are different times where people may not go through the close of escrow, and it may be a cash buy where they're not getting those documents, but that doesn't matter. Anyone who moves into your community or takes title, not moves into your community, but takes title to property in your community is automatically bound by the CC&Rs, whether or not they got a copy. It's up for them. It's up to them to do the homework, to do the research, to comply with those CC&Rs. But I'll tell you, most of the time that's an excuse. Most of the time they're just not reading the CC&Rs, or they're not researching the community or going through the disclosure documents. So we continue to see these issues. Good news here for everybody. Housing values are just continuing to increase. At some point, we'll probably see some stabilization for these numbers, but right now they're trending in this direction, and all the experts are going to say this will continue to happen throughout 2021, barring some type of catastrophic event going on. All right, so next thing we're going to talk about construction. Construction is one of the issues that if you're planning on doing construction, it's something that we need to be aware of. Right now in Arizona, there is a lot of construction. Not only construction on homes and building of community associations, but if you've driven the 101 lately, that thing's completely under construction. If you looked at most buildings and you've been to ASU, they're constantly under construction. There is a lot of construction going on throughout the state of Arizona. And what does this mean? Supply and demand. So for your associations that are looking to have projects done or looking to have things repaired, we saw this in the original boom, a lot of less skilled labor out there. Contractors are hard to find and come by. When there are less skilled laborers, this, of course, increases costs. There are more issues when these things happen. Maybe not readily apparent now, but people will then go to hire workers that may not have the skills or the expertise to complete the project that you're doing. So there may be a number of issues, not only with this, but the increase in cost. There's always issues, of course, of things not getting done. What are we going to do, and how do we get construction projects if they are being done? One of the things that we're seeing right now, because there is a shortage of construction and contractors out there, contractors are still wanting to take jobs. They're wanting to take off sometimes more than they can chew, but they're not completing projects. So what do we look at in terms of how do we remit payment? How do we hold payment back? One of the things that we're recommending right now for this issue is to always make sure under your large construction contracts that you're holding back 5 to 10% of the contract price. So that way we can make sure that the construction was completed in a skillful manner and have it inspected. That's a great way to do it. Also, if there's timing issues and those different types of things, we make sure that we have some type of built-in recourse to be able to do this. If we pay a contractor all the money and then discover issues, it's harder to get the contractor out there to correct these issues. We can go through the register of contractors, of course, but definitely if we can hold their money, find a way to do it, we are seeing great success when those issues comes up. One of the other things that you may not know is when anyone completes construction on your property, association's property, or even your personal property, they have an automatic materialman's lien against that property. And this can be difficult because anyone that provides service on your property has an automatic, or not an automatic, there's steps that they need to do to give you a preliminary lien notice, but has the right to record a preliminary lien notice against your property, even if you did not contract with them. So what does this mean? So you hire a general contractor to complete a clubhouse renovation. Your contract is solely with that general contractor. The idea is that general contractor then has to buy supplies and also has to potentially hire subcontractors to also perform work. You don't have a contractual relationship with those suppliers or with those subcontractors. However, under Arizona law, they have the right to potentially put a lien on your property if they are not paid by the general contractor. Now, there's steps that they need to do to perfect this lien. They will have to send you a preliminary lien notice in order to do that. And when you receive a 20-day preliminary lien notice, you need to take that as a very important document, because what that means is they're exercising their right to essentially lien your property if the general contractor doesn't pay them. I have had some associations in the past that have ignored those preliminary lien notice, and then the general contractor runs off with all the money, and then they're left holding the bill of having to pay the subcontractors and the material people when this happens. So materialmen's liens are very important. Anytime you have a big construction project going on, or even a small construction project going on, anyone that provides a service to that project has the ability to have a lien against your property subject to preliminary lien notice. So look for material lien notices when all those happens. Question I got, is there insurance for that? Most likely no. Most likely there's not specific insurance. You can go out and get a bond for those different types of things. There are communities that have, when they're going through large projects, ask for performance bonds, ask for security bonds. But the number one way to combat this issue, if you get a preliminary lien notice, you do not pay the general contractor for that work until you get a release. And once you get a release, then you can exchange that compensation with the general contractor. With these construction issues, again, completion, people are busy, they're not having, they're running through things. And when they go fast to complete something, what do we usually happen with that? We usually have defects. The good news is if you do have defects on any of this work, there's an 8-year statute of repose to discover those defects. But these are a wide variety of different things that we are seeing in regards to construction issues going on in Arizona. So with the housing market going up, construction issues happening, how are we going to pay for construction in the future? Reserves are important because if you had a reserve study lately, this is the question that we always want to make sure that we are addressing, because as we talked about, material costs are skyrocketing currently. So what that basically means for your reserve study is that even if you got it 3 to 5 years ago, it may be out of date. If anyone here is involved in construction, or if you've been involved in a project, you know that right now oil, concrete, lumber are skyrocketing. They're hard, not only hard to get, but the price enabled to get them is extremely difficult. I had an association that just recently, they have a large number of streets. They have a few miles worth of private streets, and they had always had a reserve study done just 3 years ago. They get a reserve study done every 3 years, and they just completed it. And they realized that they were now underfunded, not because they hadn't been following their own reserve study, but because the cost of oil and asphalt had increased so much that the new reserve study said, hey, we think you need to put away more. And with natural disasters, what's going on in Texas, anytime those can occur, it also kind of raises those costs of everything. So not only are we seeing construction and housing and all that happen, but with natural disasters like what happened in Texas or different things like that, we also see an increase. So if you haven't had a reserve study, you probably need to have them. Our recommendation is to have it every 3 to 5 years. And let me take a step back. If you don't know what a reserve study is, what reserves are the money that we are putting away, kind of like in a savings account, to whenever we need to replace an asset or repair an asset, a clubhouse, playground equipment, a pool, a street, whatever you can think of, any kind of assets in your community. A reserve study tells us what is going to be like the lifespan of that asset, and how much should we be putting away for when that asset deteriorates or needs to be replaced, we have enough money to replace it. So that's kind of what your reserves and your reserve study do for you. If you haven't got one, we always look to every 3 to 5 years, but this can be dependent on the type of assets in your community. If you are a community that does not have a lot of assets, then you may not need to get a reserve study that frequently. If you are a community that has a large clubhouse and you have private streets or private parking lot or pools or gazebos or playgrounds and a lot of variety of those different, maybe you do need to have it every 3 to 5 years. In Arizona, we don't have a legislative or statutory requirement to have a reserve study. In California, their statutes say that they need to have it every 5 years, and sometimes it can even revert to 3, depending on a number of things. But look to that as a guide. What kind of assets do you have in your community? and is saving for those assets to be repaired something of importance. One of the other things is also the age of your community. If your community is getting on the older side, 15 to 20 years, and you haven't had a lot of work, you may want to look at that because the replacement of those assets may be coming due. Or also if you're a condominium versus a planned community, condominium that maintains all the roofs and buildings and balconies and all those different types of things, you may need to have these reserve studies more often. There's also no percentage funding requirement in Arizona. You don't have, so that doesn't help us either. And some other jurisdictions, Florida, Colorado, California, they tell you what kind of percentage funding requirement you need to have. In Arizona, we don't have that. And that's good and bad because, again, every community is different. Being percentage funded may be good for some communities. I've seen some communities that say, hey, we're 400% funded. And there's a part of me that says, well, that's good, but now you're just wasting money and you're wasting assessments. You're not putting that money to use. So there is no percentage funding requirement in Arizona. But that's why we use our reserve study, is the reserve study will tell us what our kind of baselines are for the number of years. If you need to replace a roof, what do you need to be at 5 years? What do you need to be at 10 years? And we look to that to use us as a what we call a roadmap to make sure we're percent funded. But just because you hear, hey, we're only 60% funded, that still may be good. That still may be good enough, and it still may be in compliance with your reserve study. But you need to rely on the experts of those reserves to make sure that those are happening. So some of the questions I got: how often should a financial review or financial audit be done? Well, statutorily, every year under the Planned Community Statutes Condominium Act, the association is required to have a review, a compilation, or an audit done every year. Now you need to look to your documents. Your documents may require you to have one of those. So a review is a little bit less than a compilation. Compilation is a little bit less than an audit. Some documents may require you to have full-scale audits. But if they don't and they're silent, the law requires you to have one of those every year. Next question I got is, are there any situations where an HOA does not need a reserve study? I don't think so. Unless you don't have any assets, there are some HOAs that don't own any property. They're very few and far between here in Arizona. There's a couple in Ahwatukee. There's some out in Buckeye where all they do is maintain either an easement street, or they do wells, or they just do architectural review. If you don't own any property, then you probably don't need to do a reserve study. But if you do own property, which most community associations do, then the reason why you need to have a reserve study is to put you in the safe harbor. This is something that we always recommend, and why we get reserve studies, because we are all not experts in reserves. Most of you are just volunteers that don't know reserve studies. They're very complicated. But what we can do is when we get a reserve study, we can point to that document to say, hey, we're keeping up with our fiduciary obligations to the association by following our reserve study. And that helps us put in the safe harbor. And if you don't know what the safe harbor is, the safe harbor is a part of the Nonprofit Corporations Act that shields boards from liability whenever they rely on the advice of experts. So reserve study people are experts. If they give you a reserve study and you're keeping up with it, and for some reason you get sued about it, this places the board and safe harbor and protects you from liability. So our idea is when we say, hey, do we always need to have a reserve study? There's always, it seems to me, yeah, to me, it's always worth the money, but I'm an attorney. I'm always saying, hey, we need to shift that risk, protect the corporation as much as humanly possible whenever we can. One question I got: are there limits to the reserves? Can we collect $1 million without any plans to spend it? Probably not. You know, again, I think personally, if being overly funded could also be a breach of your duties as being way underfunded, because now you're just collecting money with no idea to spend it. But if there's an idea to spend it, or there's a reserve study, you're collecting money for a purpose. Which is better, special assessments or raise the dues? Well, safe harbor is always good there. And the reason why we need reserve studies, so this is a great question, Jill, because the two dreaded words in the community association world are special assessment. We want to be able to avoid special assessments at all costs. Now, sometimes we can't. Sometimes the roofs or something may deteriorate faster than was ever anticipated. So we can't predict all those of when, unfortunately, roofs just don't give out at all one time, but if we follow the reserve study and making sure that we are doing this due diligence, we can avoid a special assessment. For those of you that don't know, a special assessment is a one-time assessment that is voted upon the members, where every member is now responsible for paying a larger assessment. So we like to avoid special assessments as much as possible. So we like to keep up with the reserves and doing small increases to the regular dues to keep up with the reserve. So when we do have any of these types of events or we do need the money, it is sitting there. If you ever do want people to attend your meetings, talk about special assessments. The number one issue of boards being removed or there being issues in a community is when the association has to levy a special assessment. And some of you that are in condominiums, there may not even be approval by the members. It may be something that the board would have to vote upon on its own in order to do. Special assessments, of course, again, are all document specific. So we need to look to special assessments and our ability to do those under our governing documents. Unless you're in a planned community, you can't raise your regular dues over 20% without a vote of the membership regardless. So that's kind of like doing a special assessment if you go that way. But that's why the reserves are important. Again, you have to care about the boards. I call it the boards of Christmas future. Definitely something we need to be aware about and worry about our reserves. So architectural requests. Let's talk about these. We're seeing a lot of issues. I like to remind boards to remind their members the architectural approval process is there to protect the homeowner. People see it as a burden that the association imposes on homeowners to basically control it. And that's not the case. It's really there to ensure that when a homeowner submits a plan and it gets approved by the board, the homeowner can go forth with those improvements in that plan without repercussions. It is a process that's there to protect the homeowner from modifying their property in a way that would that be something that'd be objectionable to the association. Because we've seen it a number of times when people don't take advantage of the process, they go and build something that's in violation or objectionable. Then we have lawsuits and we have the ability to make people remove those. So we have to be very careful with our architectural requests, but we have to remind our owners that it's there. The process is there to protect them. What is the slogan that I heard from one of my clients recently was apply to comply. So I like that issue that comes up. Oh, looks like I missed a subject. So I'm going to go back here, Jose. Thank you. A past subject. If a preliminary lien notice is issued, does the HOA have the right to request their subcontractors are licensed and sufficient for the job prior to signing a lien notice? A lien notice is not something that the association has to approve. It is something that a member can file or a subcontractor can file. However, if you are not licensed under the Register of Contractors, you don't have the ability to file a lien. So they kind of go hand in hand together. Jose, that's a good question. But if you have unlicensed subcontractors that are trying to file preliminary lien notices, they don't have the right to do that under Arizona law. So I hope that addresses your question. Can the assessment be made by the board alone? Depends on the documents. In a condominium, more likely, yes. In a planned community, more likely not. But we need to review our governing documents because, again, the planned community has a regular assessment threshold of 20% that it can be raised. How do we stop retroactive requests? I'm assuming those are architectural requests. One of the ways you can do that is to educate the owners about the process, or to establish a fine policy or a policy that can violate people for simply not submitting before going out and building something. So that's one way to stop retroactive requests if this is what you're talking about. The reason why we are seeing a lot more of architectural requests, people are staying in their homes. Market's high. People say, hey, we were going to move, but might as well. We can't really buy a new place, so let's put the money equity in this house back into it, or they're trying to improve their property to sell it. So we are seeing a lot of architectural issues. One of the best things that your architectural committee needs to know, and you as a board needs to know, is your association documents when it comes to the architectural review process. Is there a timeline? Is there a deadline? This is the number one thing to know. There are a lot of documents that contain an automatic approval process that if you don't make a decision on a submittal by a certain time, it's automatically approved. And boards say, well, what if it's something that violates our documents? It doesn't matter. It's automatically approved. So we have to know if there is a timeline structure for it where we have to respond. If you get up to the deadline and you haven't made a decision, deny it. Do something, put something out there, get with your council to figure out what you can do. We just need to stop the automatic approval process. Some of it can be 30 days, some of it can be 45 days, some of it can be 60 days. I haven't seen anything less than 30 days, but it could exist out there. So we have to know exactly what our timeline is. One of the other things, dangerous thing, we have to know what we're approving. Don't guess, because if you guess and you get it wrong, you're bound by it. So again, we have this homeowner protection. They submit, you review it, you approve it. They then go and build it. If you go, well, I didn't mean to approve that, or I didn't know what this dimension said or what this drawing really looked at, we kind of don't get the ability to back out of that unless it was a mutual mistake by both parties. So if there are plans and we don't know what we're approving, or we have questions, we need to deny them and ask the question and ask for resubmittals, or we need to approve them with conditions. But the problem that I see a lot of people say, well, yeah, I missed, this wall, or I missed this detail, or different things like that. Or I thought that detail belonged to the landscaping and I thought I was only approving the house. We have to just be very careful with that. If you don't know, don't guess, sorry, or ask more questions, or clarify, or condition it. But we just have to know what we are approving, because that's when a lot of associates can get in trouble. Again, going back to that idea of this process is to protect the owner. And once we give them a green light, it's hard to undo that. So we need to make sure, one, we know what our timeline is, and two, what we are approving. And we also have to make sure that we are adapting to a changing market. Right now, a lot of people are investing money into their homes. A lot of associations have been doing things a certain way, and that's the only way to do it. But it's okay to change your documents. It's okay to update the community. There are architects out there that can help you through this process. But if we go back through construction and competition and those different types of things, we need to make sure that we are adapting to a changing market and staying up with the times. So with architectural requests, you maybe, if you're starting to get a lot of certain requests for certain things, maybe it's time for the architectural committee to evaluate those, and maybe they are good for your community, because your architectural guidelines are meant to be a fluid document, which is why they are not part of the CC&Rs. And that way we can adapt with the trends and all those things going on. One of the questions I got is a change to the home itself outside need to be cleared by the city? It depends. So reminder to all of our homeowners about the process. The association has its process and the city has its process. We are not mutually exclusive of each other. In fact, we operate independently with each other. Just because something may be approved by the association doesn't mean it's going to be approved by the city. Just because something's approved by the city doesn't necessarily mean it's approved by the association. So there may be times where the association has exterior jurisdiction over something on the outside of a house, but the city may not care. But we operate independently of each other. It's the homeowner's obligation to ensure that they are complying with both. So there's a lot of times where we've given approval for something and the city may have an issue with it. Well, that's the city's objection to do it. Somebody may get a building permit from the city, but it may not comply with the association's restriction. They have to comply with both. And usually it's always going to be the more restrictive provision is going to control. And people say, well, what does that mean? Well, if the HOA has a 20-foot setback and the city only has a 15-foot setback, the association's setback is more restrictive, and now the person's going to have to build at the 20-foot setback. So whenever the association and the city have mutual exclusive jurisdiction over something, most of the time it's going to be the more restrictive provision is going to control. But these are all the things that we look at in our architectural requests, and we look to see if we can adapt and change with those things. But that's a very good question. All right, so some of these good ones, we've got a couple of really good issues left, and I know I got about 30 minutes left. So contracts, number one association mistake is made with contracts. Attorneys hate contracts. And why do you think attorneys hate contracts? Because it takes away our jobs. Really what it does is I've preached this to boards for a long time, and every time I get an opportunity like this to tell you, if you come to me with a contract to review at the beginning, it's cheaper for the association for me to review at the beginning. If you come with me with a contractual problem or the lack of a problem with a contract at the end of it, it's usually a lot more expensive to correct an issue that you didn't contract for or you didn't have reviewed by your attorneys. So if you want to avoid using attorneys, have your attorney actually review it at the beginning, because they're more likely not to have problems at the end. And if it got messed up, then it's the attorney's fault, not the board's fault. And that's why I also have malpractice insurance. But a lot of people don't go to attorneys to review their contract. And this creates a problem, because if you sign it, you're bound by it, regardless of what it says. So I always tell this, and I heard this from a good attorney, think of when you're entering into a contract as the prenup. Most people, especially associations, when you're entering into a contract, it's usually for a good thing, right? You're building a new project. You've entered into a new landscaping contract. You have a new playground inspection. You're doing something proactive for the community, and you're happy about it. And the contractor's happy, right? The contractor's happy to have a lot of work. I always kind of say, think of it as a prenup. You know, everyone in a marriage is happy at the beginning, right? When does a prenup become important? Not when everyone's happy, when everything dissolves. But when it dissolves, at least you have an agreement that you made when you were happy. So it's always easier to make an agreement when everybody's happy at the beginning than it is to go back and fix an issue when everybody is upset, because you can't go back in time and you can't change the language of a document that you've been abiding by for a certain amount of time. So we have to be careful. So look to what you are entering and say, hey, yeah. And sometimes you go, hey, like a prenup. Nobody likes to enter into prenups because everybody's happy. We don't need that. Nothing's ever going to go wrong. Well, guess what? Things can go wrong. Good marriages can go wrong. And so if we prepare for it to go wrong at the beginning, we're going to save ourselves a lot of time and money and heartaches at the back end of it. Because guess what? Your vendor contracts that your vendors are presenting to you, guess who they're there to protect? The vendor. The lawyer for the vendor most likely drafted that contract. They hired somebody to do it. And most likely there's a lot of waiver clauses, indemnity clauses, or one-sided provision that protects the vendor. Rightfully so. They're the ones that hired the attorney to go and do that. But if you're willfully entering into that, you got to think of, hey, where's this coming from? It's coming from an agreement for somebody that's trying to set themselves up to protect them, which is okay. But you have the right to be able to set it up so you are also protected. And we have to be careful about the contracts that we're entering into, or work orders or things that we're signing subsequent to a contract. True story, we had a contract that was going on. We took a week to review it. It was a great clubhouse contract. It was for a remodel. Everything was going great. At probably about 6 months in, the association said, hey, there's big problems with this contractor. We need to go after them for X, Y, and Z. I said, great, we have our contract. X, Y, and Z should be covered. Boom, boom, boom. We send a demand letter to their attorney. Their attorney then comes back and says, hey, listen, that provision's null and void now. Why? Because we had a subsequent contract after that contract that the board president signed that nullified the protections in the association's original contract. And it was in the part of it. And the board president said, I just didn't think anything of it. I thought I was signing something that was pretty standard. Well, what it did is it changed the terms of the contract, the original contract. So we have to be very careful anytime you're signing something. It's the advice that I give to my family. The number one thing I can always give any of you, even personally, don't sign anything without reviewing it. We click on a lot of things, we accept a lot of things, but we have to be careful whenever we are signing things. So also be careful with that. And one of the things that we get from a lot of boards is going, okay, but we have a threshold, Josh. We don't want to spend money on you unless the contract is for more than, I'm just going to make up a number, more than $1,000. So if it's more than $1,000, it goes to you. If it's not, then we don't send it to you. Well, that's dangerous because there's a lot of contracts that we may enter into that are for less than $1,000 that are more important than some of our bigger other contracts. Why is this? Because what's the work? Is someone repairing a roof? What if somebody falls off that roof? What if that contractor drops a tile on somebody's head from the roof? What is the agreement? Who's responsible for that damage? Who has to indemnify who? Those different types of things. So we have to focus on what is the work? What are we asking to be do? Is it dangerous? That's also with the skill level. Is it something that only these people have the skill set to do? And also, what is the liability? One of the most important things that I say is go get your playgrounds routinely inspected. There's great playground inspectors out there. That is something that's very cheap. Most of the time they'll go out and they'll look at your playgrounds for $300 to $500 and give you a report. Well, guess what? That's a lot of liability for that person that's inspecting the playground, because what if they miss something? What if they don't tell you about something and then a kid is extremely injured by something that they missed? $300, $500 issue. We relied on them to give us a report. They missed it. But guess what? We didn't have good language in our contract. So now the association's left holding the ball. So we do have to be careful with not only focusing on the dollar amount of the contract. We sometimes have to say, hey, is this something that could expose the association to liability, or is it something that's very important to the association? And if you do, then you need to have it reviewed by your counsel. Again, that money spent up front will not only get you in the safe harbor that we talked about, but also let your attorney shift as much risk away from you as humanly possible. I got a question here regarding the second contract signed by the board president. Was the first contract approved by the board, and did the president sign the contract without board approval? No. The board had given the board president, delegated the board president the authority to enter into subsequent contracts. So they delegated that authority as basically being a project manager for it. So nothing really that the board president did that would cause a big issue. Didn't think he was doing anything wrong, but you know, it's again, one of those things that we just have to be very careful about, because again, that amount of that contract was not a large dollar amount, but it was an amount, it was a contract with somebody that was doing a large project for the association. So they really didn't think about it. So that's a very good question. All right, so contract essentials. So I'm going to give you kind of the behind the scene, take away more money from me, things that probably should be in every single one of your contract. The term, how long is the contract for? Is if it's any type of term contract, when can we get out of it? When does it expire? How long does it go for? How is it renewed? Termination. Can we get out of the contract? That's the very first thing Carpenter Hazelwood's going to look at is saying, hey, you need to have an ability to get out of this contract. If you don't, and it's a term contract that's guaranteed for 3 years regardless, you may have to write a check for that 3 years to be able to get out of that contract. We need to make sure that we have an understandable termination clause that you and the contractor can both work with. And that can be, all these can be mutually exclusive. Insurance. We want to make sure that our vendors are carrying insurance. One of the things I always tell people is, hey, if you use Carpenter Hazelwood, we have malpractice insurance. If you ever want to request a copy of it, I'm happy to send it to you. You know how many requests I ever get for it? 0. But we need to make sure we're having insurance, or we need to make sure that there's a requirement under the documents that they carry a certain amount of insurance, or that the association may be named as an additional insured under the contract. Indemnity. If the contractor, vendor, whomever it may be, causes a problem for the association gets sued, we want to make sure that gets sued for the work of the vendor contractor. We want that contractor to take care of the problem. We hired them in order to do this work for us. And if we got sued because of their actions, we want to be able to shift that risk back to them. Only way of doing that is make sure that we have a contractual indemnity provision. Damage. If there's damage on the property caused by the contractor, do they have to repair it? What is their obligation to repair damage and be responsible for damage? Payment terms. How often do we have to pay? When do we have to pay? When's our last payment? Under Arizona law, is there the prompt payment plan that's required? We need to look to all of these things to make sure that they are in our contract. We have payment terms. Time is of the essence. When does it need to be completed by? Is there a punitive provision at the end of it if it's not completed in a certain amount of time? Liens that we talked about earlier. How are we going to handle liens? What happens if we do get a lien? Different things like that. We make sure that associations are always going to be aware of. And one of the most important things is when we have vendor relationships is we need to make sure that we are establishing them as independent contractors. This is important because independent contractors, we have different responsibility if somebody falls into the threshold of an independent contractor versus an employee. Independent contractors, they hold their own liability for any kind of injuries that they suffer while working. If somebody's an employee, the employer holds some responsibility if they injure somebody or they're injured while they are working. And we may think of, oh, that's easy. We don't have any employees. Well, if someone's constantly on your property, you control them. There's a variety of different factors in Arizona law. The law may still see them as an employee, even if you treat them as an independent contractor. So one of the things that we do under contracts is we make sure that we have that essential term that identifies them as an independent contractor to help, again, shift that liability. All these contractual provisions are doing two things: setting expectations and shifting liability as much as we possibly can. Next topic, talking about a little bit of unemployment. Unemployment is on the rise in Arizona. It's kind of stabled out a little bit now. But as you can see of where we were at in January and how the pandemic hit people, we're still having pretty high unemployment. The good news is it's dropping a little bit. And as things get back to normal, I hope it continues to drop. But there's a large amount of unemployed workers out there in Arizona. And right now, again, it's kind of confusing because most of the time that data would not relate to the fiscal stability of all of our associations. Our delinquencies are down. Employment's up, delinquencies are down. There's a wide variety of this: disposable income that we talked about earlier, equity and property, stimulus packages, different things like that that may be help masking this issue. But if employment stays high in Arizona, we can imagine that this would create problems with associations. People who can't pay their assessments, increase in bankruptcies, death or loss of ownership of certain property, violations go up because people can't afford to maintain their property, they can't spend the money to do it, hire landscapers, do all that kind of stuff. They may have to get involved in various types of reverse mortgages. They could see not paying their taxes and having tax liens, or not paying their properties and having Arizona property tax liens. All these different types of things that could cause an issue with your community associations if we continue to see unemployment rise, or we start to monitor our delinquencies as they continue to go down. Again, this is just something that really may not be an issue for you now, but it's just something you need to keep in the back of your mind of a legal issue that can continue to happen and something that you may need to prepare for towards the end of 2021 as we continue to go out of this pandemic. And the reason why we always bring this up, the longer you wait to get paid, the longer it takes to collect, the harder and more expensive it is, and the worse your results. And this happened to associations in the downturn. People were losing their jobs, losing their homes. Associations, wanted to be a social safety net, and we're letting delinquencies go and not getting on top of them. And the larger those delinquencies got and the longer we let them sit out there, the harder they were to collect. It doesn't necessarily mean that you have to go and be the heavy hand, but it definitely just means you have to get in front of it and have to be aware of it. You know, it's always those things that we don't like to be callous, but an association can't be a social safety net, because then it falls back on the owners who are paying to pay more. That's just how it works in the association world. So that's kind of the collection's golden rule of doing those things. Question I got: as an association, are we mandated to participate in reverse mortgages? No, you're not mandated to participate in reverse mortgages, although they can be out there. AZDRE complaints, want to just talk about this. They continue to rise. So if you don't know what an AZDRE complaint is, there's a statute in Arizona that gives the AZDRE the ability for a homeowner to file a complaint. They have to be a member of the association to file a complaint against the association for violations of the governing documents or violations of Arizona law. And then basically it's just a form that you fill out. You have to pay a $550 fee per issue. And then you get to have a hearing in front of a judge, and the judge gets to make a ruling of whether or not the association violated its governing documents or violated Arizona law. And if that occurs, then there could be sanctions levied by the administrative law judge against the association for violating it. And you would have to repay the homeowner their fee for bringing the claim. Here's the troubling part. If you win, guess what you get? Nothing. It's one of those things where, because it's administrative law court, they can't award you their attorney's fees. And also you get a clean bill of health and you get to be proven right. And the owner's out their $550, but that no money goes back to the association. So these are kind of real issues when we see these continue to rise, because it gives the members of your community the ability to go in and challenge the association for any issue that they can think of for violations of the governing documents or of the Arizona law without very much repercussions. Most of the time it's just out $550 or whatever they bring to claim. And the reason why we're seeing a rise in this, a lot of people have disposable income, you know, and we're starting to see for $550, I can go challenge my association on this. I've got $550 to risk. So more money creates more problems for the association. That's that whole thing. If you remember the movie, I believe back in the 90s, of more money, more problems. So we continue to see these kind of claims to rise. The good news is we are winning a lot of these issues. And the reason why we are is because the judges are staying in their lanes. These judges are lawyers, and basically they know their jurisdiction. They need to see a pure violation of the governing documents or the law. So they limit their scope of the issues. And they're doing very good at following it. However, even if there's a technical violation of the law, like we had a client here in the firm that they get a records request out on the 11th day because their computer had issues. And the judge found that, hey, you had 10 days to get to him. You got to 11, even though there was documented issues. And the court said, hey, we believe you, but a violation is a violation. 10 days is 10 days. And so they awarded that owner their $550 back, but that was it. So he went through all this cost, all these issues to fight. And the reason goes, well, can an association just not fight it? Well, the problem is by not fighting and ignoring it does expose the association to potential sanctions. And so we want to be very careful with that. George, your question here that I'm seeing is kind of long and detailed. I'll try to get to it more kind of at the end because I know we're kind of running out of time here. The other reason why we're seeing an increase in this, more AZDRE complaints, more education, the internet next door is telling people how to go file these complaints without very much repercussions. Also, the Arizona legislature has been involved over a couple of years ago where we have to put in our violation letters that owners have the right to come and sue us. I mean, that's the legislature hard at work, is saying, hey, here's a violation of your documents. If you want to contest this, you can appeal it, or you can go to the Arizona Department of Real Estate and file a claim against the association. So we're mandated to include that notice language. Is there insurance coverage for fighting these claims? Depends. You may want to check with your carrier to find out if there's coverage for these things. Even if there is coverage for them, some of them are pretty easy to resolve, and some associations don't like to tender them. But there are a number of members who are using this process to constantly bring claims against the association. and the association cannot recover its attorney's fees and costs for hiring an attorney to go and combat these issues, even when the association prevails. So it's something that I think we're going to continue to see. I think it's going to continue to become more popular, and I think it's also going to become a way that members are going to use to continue to harass associations or to continue to drag them through the mud. Okay, so I want to talk about a couple more issues here. This one's probably my most favorite one. Would E&O or D&O cover that claim? Most likely you don't have E&O insurance, errors and omissions. Most likely you have your D&O, your directors and officers policies. That's what you probably need to check with your carrier. Some policies, some D&O policies may not cover administrative cases because that's not really considered litigation. It's called administrative action. So one of the questions you may want to ask to your carrier is, does this policy cover administrative claims? So Alan, that's a very good question. So there is a bill currently going through the legislative process that I'm referring to as the Community Fistfight Bill. And it's House Bill 2052. So you can Google it. I also have this link that has been sent out to you in the presentation. So you can just cut and paste this link. But here's basically what it does. There's 4 parts to it that I think are important. The first part of it is this is what they call it, the Political Community Activity Bill. I refer to it as the Fistfight Bill. First part of it is associations cannot prohibit or unreasonably restrict a unit owner or a member's ability to peacefully assemble and use private or common elements, so your common property, of the community, if done in compliance with the reasonable restrictions for the use of that property adopted by the board of directors. So peacefully assemble, meaning that they can have protests in your communities or on your common areas if they are a unit owner or a member. But that unit owner or member's ability to peacefully assemble with who? The general public? Are they allowed to now have protests inside your community? Can any member have the ability to hold these? And although the association gets to adopt reasonable restrictions, and I'll tell you, anytime you throw the word reasonable in front of something, you're just asking for lawyers to get more involved. But those reasonable restrictions cannot prohibit or unreasonably restrict the ability to peacefully assemble inside your communities. Some of you may have clubhouses. Some of you may have pools that are all common elements or private property. That may give somebody the right to protest inside your clubhouse. This is very problematic because it's not really giving us the language that we need to address these issues. And I know that the politicians think that this is right, but we are private property. You know, that's the one thing we have to remember, that the association's common areas and common property is private. This would be the equivalent of telling a legislature telling you that on your lot, someone's allowed to come and protest on your lot. It's private property. The board's in control of the private property, but this bill would allow members to peacefully assemble, protest, or gather, or vigils, or all these different kinds of things that you can possibly think of on your common property. And it doesn't really talk about, is it only for them, or can they sponsor it and have members from outside the community come and go? So we look at, like, what would reasonably restrict that? Would it have to have insurance? Is that a reasonable restriction? Are we allowed to talk about the type of what they're going to be? Are we allowed to limit the number of guests? What are we allowed to do with reasonable restrictions? There's no guidance here with that. So that makes it extremely difficult. It's very, very problematic. And that's only the first part. The second part of this bill basically then says, this also includes an individual unit owner or member or group of unit owners or members are permitted to organize, to discuss or address association business, including board elections or recalls, potential or actual ballot issues or revisions to the community documents, property maintenance or safety issues, or any other association business or action. So what that means is now you have to make the common property again available to individual unit owners to hold association type meetings to talk about association business without having to go through the notice requirements that the board and the membership is subject to. So this creates a whole bunch of issues. So you think about, hey, we know that the board wants to pass some kind of special assessment, an amendment. There's an election coming up. We know that the board's has its call of candidates, but we want to have a second candidates meet night and a second time to badmouth candidates or different things like that. So this is the thing. So it opens up your common areas and your ability for all your members to use your common areas, for them to go and discuss association issues without having to adhere to the strict requirements that the board and the membership may have for these types of issues. So it basically is opening up the common areas for people who are against the association to come in and use association property to basically rebel rouse and to draw up steam to defeat any kind of association issues. At least that's how we see it working. So that's also problematic. My biggest issue is with this part of the bill. So as you know, political signs are protected under the Common Act of Planned Communities. This would be the time where they expand the definition of a political sign to include any activity to elect or remove an association director, or to circulate or oppose petitions for actions in the association, or in support or opposition to association ballot measures or other questions. So you guys all running for the board, you board members on here, this would allow members in your communities to put up signs that could say, don't elect Josh Bolin to the board of directors. And it doesn't say it has to be that thing. It doesn't. It just says any activity to elect, any sign regarding activity to do all this. So the trouble with this is not only does it expand political signs to include association issues, but it doesn't remove any of the other political sign protections. So 71 days before and 3 days after. Imagine all the association issues that you have. Somebody could literally have an association sign out in their property all year round, because I don't know what oppose a petition for actions or ballot measures or other questions. You know, they don't give us, the legislature, of course, does not give us guidance on what that means. And so to us, we're going to now have to allow, if there's an election or a vote, or if there's written consent out there, or maybe even if you have something on your agenda that comes up, that they may be allowed to put out political signs that basically address association issues. So it's problematic, and I do think, given the associations, this could cause a lot of issues. You know, what could you put on a sign? Could you defame someone? What if an owner defames a board member? What if somebody defames a member of the association? What if there's all these different types of things? It's problematic. I mean, all of you on this call, you could imagine what some of your members could probably come up with. And it doesn't talk anything about vulgarity. It doesn't talk about obscene issues. You know, it's pretty much out there. And the other political signs is they don't have to be manufactured signs. There's not a location requirement on where they could put these. So if somebody put it up in their window or on the garage, the good news is we still have like the size limitations, but it addresses political signs that now have to do with association issues. Associations aren't governmental, but we are sure being looked at as governmental, and we're now getting all these different types of things that make us deal with governmental issues. So one of the questions that I have is what if a board member calls a meeting of the member? Doesn't matter. Board members, your members, if this passes and they want to peacefully assemble on the property or oppose the action of the board, I don't think there'd be anything prohibiting a board member as a regular member of the association from doing that. At least there's nothing in this document that would stop that, which makes it, that's a very good question, makes it also problematic. To say the least, there's so many issues with this. Yeah, that's right, Vita. There's so much that goes on with this. And imagine the election that we just went through, and imagine that being all year long with your associations. That's why this is problematic. So the question that you may get is, why would the legislature be interested in it? Well, most of the time it's follow the money or follow the motive. And the last part of the bill is a unit owner or a member is allowed to invite a political candidate or other non-unit owner guest to speak to an assembly of unit owners or members. So what does this mean? Someone that's not on your board would have the right to invite any candidate, city council, Arizona representative, federal representative, or any guest speaker to come in and speak to an assembly of unit owners or members. So that could mean Arizona legislatures, right? That's probably why they like this bill. And that's probably why it's already passed out of the House 59-0. The good news right now is that this bill is currently in front of the Senate. So going back to civil procedure here, House introduced it, went to committee, House has now passed it, it's got to go to the Senate. Senate's got to review it, Senate's got to vote on it, Senate approves it, it will then go to the governor to sign. What you can do is if you're outraged by this bill, kind of like I am, just because I definitely do think it's problematic in its current form, you need to complain to your representatives. Each one of you as individuals needs to email them about this or pick up the phone and call them to basically to go there. You can go on, if you just Google who are my Arizona state representatives, all that will come up. So contact your local representatives, your state representatives regarding this issue. So again, this is not going to pass, it hasn't passed yet, but it's got the full steam ahead of passing. And it could create a lot of issues. So we are very concerned about it. So sorry, Steve, you're right. Hour and 15 minutes. I'm over my time. Got a lot of good questions. So last topic I'll get over. What's the new normal? I hate this term with a white hot passion. I don't like the term new normal, but it's something that gets thrown around quite a bit. I'll come back, Jeanette, and answer your question. Let me cover this real quick, and then we'll get back to what you can do. So when is this going to happen? We don't know when the pandemic's going to end. The state has set benchmarks of when things can start to open back up. As you know, we're kind of on the wrong side of those benchmarks, but we're trending in the right direction. So definitely what we can start to do is prepare for what opening is going to look like, getting back to new normal. So when, there's no date in sight, but we can start to think about it. What does this mean? Well, when can we start having in-person meetings? If you're not having in-person meetings, is there events that we can start to have? Are there uses we can start to think about when this is? Now, I'm not encouraging you to open these now. Get with your general counsel, still look to CDC guidelines. We have to still be concerned about the lack of insurance coverage of potential claims for these things. But if we continue to trend in this direction and we are going through all the right things of masks, vaccinations, distance, and virtual learning, and keeping our distance like this, then maybe we're getting back to it. But one of the issues I think legally that we're going to see is as things start getting better, when are we going to be able to start operating as we used to? And when are we going to be able to maybe open up our clubhouses? Your clubhouse is cold, get rid of our mask mandates, all those different types of things. These are different things that we have to continue to go over. Our concern from a law firm, always insurance and liability. If you don't know, your insurance coverage most likely has an exclusion for pandemics. So we don't have insurance coverage if ever there's a claim brought that there's a wrongful death or an injury of somebody who caught COVID and got really sick on your property. That's our biggest concern, is the lack of insurance coverage and the liability that may come with that. We do know the liability is suspect. One, it's hard to prove of where anyone ever got sick unless there's a common denominator. And the other good news is we haven't seen any lawsuits yet regarding, especially against associations, basically alleging that the association's practices caused somebody to get COVID and get sick. So those different types of things still exist, but it's time to start planning those different types of things. Question I get is, our community garage sales, okay, depending on how you have them, depending on the protections that are in place, depending on where they're going to be, can there be social distancing, can we comply with CDC guidelines? how can we do all that kind of stuff? So I'm not going to basically write off on it, but get to with your general counsel to give them some thoughts and different things like that to help mitigate some of that liability. All right, so here's a question. Do you ever have to go back? There's some things I hope we never go back to. I'll be honest with you. I enjoy virtually attending meetings. Saves a lot of driving. Seems like a lot of our meetings can occur earlier when we have them virtually, so we don't have to drive from work. We can have these things. Can we continue to operate virtually? Absolutely. Can the boards continue to meet virtually as they have been? Absolutely. Definitely, there's things that could change that may be for the better, that may have forced us to get out of our comfort zone of continuing to having to meet in person at 6:30 at night at the school and do all those things. And maybe we can take advantage of being forced into doing things from our home that may allow us to be with our families and not have to travel as much and not have to be exposed so much and being able to participate more often for those of you who are busy and for travel. So there's not an obligation to go back so long as we're complying and continue to comply with the law. So that's the presentation. So I'm going to come back and answer a few questions that are right here at the end. One of the ones was key points to make to our legislature, that this will cause your community to fight constantly. One thing about association issues is people can get very principally driven about an association issue. I always tease my sister, who's a prosecutor in LA County, that her criminals are nicer to her than homeowners can be to me. They just bring out sometimes the worst in people, and allowing people to put up signs for any association issue will also allow people to have signs in their front yard constantly. And politicians who run for public office have a different threshold than somebody who's just looking to volunteer for their neighborhood community association. It's going to have a slippery slope of those who may want to run. You know, I'm not going to want to run if my neighbors are going to have signs out there bad-mouthing me and all those different types of things. Also, it's private property rights. You know, this is legislation that may have constitutional problems, that is requiring private property owners to open up their property, especially to government employees. That makes it very difficult. All these different kinds of things that we talk about, voice those concerns to your representative as much as possible. If you disagree with it, there may be some of you on here that agree with it, and that's okay. I just think as it's written, it's problematic for a number of reasons. Let's see. Do other ungated HOAs have issues with street parking, and how have they addressed these issues? Mr. and Mrs. Weiss, I could answer that for you, but it would go on for an hour. Definitely there's a way to combat street parking issues. Street parking is the black sheep of the association family. Very difficult to do, very problematic. Search with your vision, your manager, work with them, work with your general counsel, but there are ways to address it. But I will tell you that it is one of the hardest issues to address is street parking, especially on private or public streets. Someone's asking, can the city help? Yep, city can help, especially if they're public streets. If they're public streets, the city has the ability to add speed bumps, no parking signs, paint curbs, do all those things. The association doesn't have the ability to add those to public streets, but the city or the municipalities definitely do. Can you address the ability to allow all to speak during a virtual meeting when the boards meet virtually and some board members are shut off from speaking and not recognized or not allowed? Again, so that's all going to be meeting code of conduct issue. Members are allowed to speak and participate before the board takes action, before the board votes. There should be that comment period that takes place with board members and being able to speak virtually. There's probably some meeting conduct and different things that can be put into place. But most of the time the board needs to have some of that conversation back and forth, again, all limited to being a reasonable amount of time. Because just remember, your board meetings are the time for the board to do its business. And although I broke my own rule of going over an hour and a half, got to make sure that we're being efficient and getting things done. There are city regs about on-street parking. Thank you, Josh. Thank you, Josh. I appreciate all of you having me out. What can a board do when a board member continually violates the open meeting law? Education of the violations of the open meeting law. Hard part is usually one board member can't violate the open meeting law. Sometimes because you have to have a quorum of the board to gather, discuss, and association business to violate the open meeting law. But if they are out there sharing privileged information, get with your general counsel. There are ways of addressing those issues. Barnes, reach out. That's a good question. Not for me. All right. Well, I think that's it. Again, I really appreciate everyone taking their time out. If you ever need anything from Carpenter Hayeswood, anything from me, always happy to help. Always happy to give up our time. Very thankful for Vision for giving us this opportunity to present. Thank you, everyone for taking your time out of today. Know your volunteers. Know it's late night, and so greatly appreciate and hope you found this presentation to be very helpful. So thank you very much and have a lovely evening.